Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, Helen. Hello, everybody.
Now, in a week where GMB staff have voted to strike over a lack of action on a report which branded it institutionally sexist, more areas get level 4 devolution powers. And we learn that councils are in the top 5 offenders for data breaches, although in reality they sit in joint third place with only health and education above them. Dennis and I take a walk through the highlights of the LLG Bulletin. And we're back on the theme of ethical standards. Dennis.
Indeed. In-house lawyers and ethical and standards issues will remain on the agenda for the foreseeable future. The SRA are consulting on new guidance in the aftermath of the revelations in the post office scandal, which, according to one commentator, has highlighted a number of behavioural weaknesses. Let's take a look. Lawyers' lack of interest in ethics may be fueling an increase in rogue behaviour in the profession, an academic expert on the legal profession has suggested. Professor Richard Moorhead told a conference of lawyers that apathy and ignorance were a root cause of unethical behaviours that have manifested in issues such as the post office scandal. In a wide-ranging discussion on lawyer ethics as part of the Legal Services Board conference in London, Moorhead said some practitioners had also taken advantage of uncertainty about what it means to act ethically and applied a narrow approach to what was right. The post office scandal had revealed weaknesses in professional rules and highlighted occasions where lawyers were either ignorant about their responsibilities or too clever by half. Although the consequences in the post office case are extreme, he said, the behaviour is not that unusual. The things that Moorhead highlighted included putting clients' interests first before the interests of justice, before integrity, independence, and honesty, using the law and confidentiality in particular as a tool to take advantage of people in their thousands. Moorhead said the in-house community especially was crying out for more guidance on how to be compliant and stay independent in the face of pressure from employers. Solicitors Regulation Authority Chief Executive Paul Phillips said that in-house guidance is on the way, but suggested there may be a wider problem that the profession needs to address. Turning to external lawyers, he said, there is a culture in external law firms that allows this to happen, he said. There's far too much of lawyers seeing themselves as a hired gun and having little respect for the rule of law. And Charlie Hult, European lead at the organisation Global Legal Climate Defence, said aggressive litigation in the form of slaps was a systemic issue and symptomatic of a failure to attach appropriate value to obligations around the rule of law. Holt went on, we see the same law firms and lawyers popping up again time and time. Having worked in Europe, he said, there is nothing comparable to the UK in that respect. There is in the US, and we see these belligerent lawyers appearing again and again. And Tetyana Nesterchuk of Fountain Court Chambers told the conference, you could be advising the client within the confines of the law, but there does come a point where you have to think, does it pass the smell test? That's what I always have to ask myself. Is this something that I'm comfortable doing? And the moment you get uncomfortable, you have to ask yourself, why? Helen.
Well, part of the issue is being wrapped up in an atmosphere of this being the normal, Dennis, of confusing the protection of the organisation with the independence of effective scrutiny and legal duty. We're talking about this in the LLG vlog this week, so listeners should definitely watch that and also let us know their views. We are always interested in member views. Now then, Simon Hoare MP, Minister for Local Government, has urged monitoring officers to look sympathetically at requests from councillors for their home addresses to be withheld from the Register of Interests in a letter sent to chief executives. The letter states that the sensitive interests provisions provide for details about registered interests to be excluded from versions of the Register of Interests available for public inspection or published online, where a member and monitoring officer agree that the disclosure of that interest could lead to violence or intimidation of them or their family. They provide for members to disclose what they have an interest in, but for the details to be withheld from the public register. Now, Mr. Hoare asked that on receipt of the letter, quote, he said, "I would be grateful to you bringing the contents to the attention of all current members of your council and your council's monitoring officer. The government encourages monitoring officers to look sympathetically at accommodating requests for the withholding of home addresses from published versions of the Register of Interests where there are legitimate concerns of violence or intimidation." Now, let's not forget, how could you? I mention it frequently that the Committee on Standards in Public Life called for a change in the law on the issue of the disclosure of council addresses. And really, it's got to be a no-brainer given the huge percentage reports of harassment, threats and fear for life in some cases that councillors have reported and indeed endure. And really only seems to be getting worse. It really is. So please make sure your monitoring officer is aware of this letter. So, as I've said, with threats of violence against councillors rising, what's the impact of the new extremism guidance fresh out from the government, Dennis?
Well, Helen, this is interesting because according to the latest government guidance, inciting violence towards councillors could constitute extremism. Let's take a closer look. Using threatening, inciting, justifying, glorifying or excusing violence towards members of local government could be considered behaviour constituting extremism under new guidance issued by the Department for Levelling Up, Housing and Communities. The guidance introduces a new definition for extremism alongside new engagement principles as part of an effort to counter extremism and religious hatred while promoting social cohesion and democratic resilience. The document says the engagement principles are for government departments and are aimed at ensuring they are not inadvertently providing a platform, funding or legitimacy to individuals, groups or organisations who attempt to advance extremist ideologies. The document partly defines extremism as the promotion or advancement of an ideology based on violence, hatred or intolerance that aims to undermine, overturn or replace the UK's system of liberal parliamentary democracy and democratic rights. And it added that attempts to undermine, overturn or replace liberal democracy could include using, threatening, inciting, justifying, glorifying or excusing violence towards public officials, including our armed forces, police forces and members of local, devolved or national legislatures in order to dissuade them from conducting their obligations freely and fearlessly without external interference. The department claimed that the new definition adds to the tools to tackle the threat from extremism it said has been growing steadily. However, the department did say that the definition itself is not statutory, has no effect on the existing criminal law, and only applies to the operations of government itself. Now, since the announcement of this guidance, it has clearly proven to be highly controversial. And in the wake of the announcement, a number of MPs have already expressed concerns about the guidance and its possible effects. Helen.
Well, we'll just have to see how it plays out, I suppose, Dennis. Now, turning to a subject we haven't raised for a while in the podcast, but something of vital importance: climate change. The LGA has released a report entitled Climate Action: International Learnings on the Governance of National and Local Government Collaboration. In the report, the LGA states that councils in England are taking innovative steps to tackle climate change, including declaring climate emergencies, developing action plans, and rolling out demonstrator projects. However, they also face significant challenges, such as a lack of dedicated funding and uncertainty over financing options, amongst other things. The Local Government Association recognises the importance of local government in delivering impactful climate action that helps to create prosperous communities. And the LGA also acknowledges that effective support from national government is essential. And they have been multiple calls for greater clarity over the role of local government in implementing climate action, and a need for improved coordination between the national and local levels. Now, in the report, the LGA drew a number of conclusions from their studies, including that national climate policies, legislations and programmes should be explicit about the intended role for local government. Local government should be enabled by national government to take more ambitious opportunities locally and to apply locally relevant decision frameworks where most relevant. Vertical integration and coordination are key to ensuring clear collaboration. Local governments can account for negative externalities while funding a just transition. Well, what does that mean? Well, governments raising funds to subsidise a just transition while accounting for negative impacts that neither the provider nor the acquirer are ordinarily required to fully pay for or address, such as the environmental impacts from polluting activities, for example. Central government can enable more flexible access to funds for climate action and allow for more flexible use of funds. And central government can provide more certainty on the allocation of climate action funds. Now, I would urge lawyers to read this report to help them pivot when advising their authorities on the actions they take to respond to climate change. It's good to see it highlighted, Dennis, if only to keep it on the agenda, frankly. Now, we rarely cover case law, but when we do, it's because it's rather interesting. Dennis.
Indeed, Helen. From time to time, we do like to bring you a good news story, or one perhaps that appears as a bit of an oddball, but this next item is a bit of both. Here's the detail. Global tech firm Apple has agreed to pay £385 million to settle a lawsuit led by Norfolk County Council. The class action alleged the tech giant's boss, Tim Cook, defrauded shareholders by covering up lower demand for iPhones in China. Norfolk Council said a pension fund it administered lost money as a result of Mr. Cook's actions. In a statement, the Norfolk Pension Fund said it was very proud of this recovery for investors. The statement continued, "We are mindful that we are stewards of pensions relied upon by thousands of families and individuals. When and where it's warranted, we will take decisive action to recover losses when our participants' investments are harmed by fraud." Now, the BBC did approach Apple for comment. The class action lawsuit itself, meaning it's on behalf of a group of claimants, centered around comments made by Apple's chief executive, Tim Cook. He told investors on the 1st of November 2018 that there was sales pressure in some countries, but he would not put China in that category. However, 2 months later, on the 2nd of January 2019, Apple downgraded its quarterly revenue forecast, citing tensions between China and the US, leading to a sharp drop in Apple's share price. Within that 2-month window, reports emerged that Apple had told its top smartphone assemblers to halt plans for additional production lines for the recently released iPhone XR. The claimants in this case were all investors who had bought shares between November 2018 and January 2019. They said that they had lost money because they'd been falsely reassured by Mr. Cook's comments in November. Now, Apple had fought the litigation and a trial was scheduled for later this year. But this preliminary settlement should now mean that that case will no longer happen, but it still requires approval by a judge. Now, it's not known what portion of the settlement Norfolk County Council will expect to receive. But to put this in context, Apple posted $97 billion of net income in the last fiscal year. The payout equals a little under 2 days of profit for what is one of the world's wealthiest companies. Wow, Helen.
Wow, indeed. But this is great news for Norfolk, so good luck to them. Now, finally, from me, ministers are considering removing the power for councils to make profits when fining motorists for minor traffic offences, things such as stopping in yellow box junctions or driving in bus lanes. The Department for Transport has put out a call for evidence on restricting the generation of surplus funds from traffic contraventions. The call for evidence is designed to A, gather evidence of current practice to inform possible policy proposals, and B, explore options for restricting a local authority's ability to generate surpluses from traffic contraventions. The Secretary of State for Transport announced in the plan for drivers' action to address concerns about several motoring matters, including councils generating surpluses from issuing penalty charge notices and for contraventions of moving traffic restrictions. Examples of such traffic restrictions include things like no entry, no left-right turn, prohibited vehicles, unlawful entry into box junctions, and driving in mandatory cycle lanes. So since 2003, London councils have had moving traffic enforcement powers, and the decision was taken in 2020 to make those available to local authorities elsewhere in England. Wales is separate to this. Statutory guidance requires that for the first 6 months of operation, councils issue only warning notices to first-time offenders, and this also applies to any new camera location, by the way. Now, in October last year, the Evening Standard reported that there were 3,192,000 moving traffic offences in 2022 to 23 when drivers ignore the road signs. This consultation closes on the 11th of May, and it's open to the public as much as the local authorities concerned. It's contentious. It would mean a drop in revenue for local authorities, but then it comes at a time of austerity for individuals who fall foul of the rules and invoke the fines. So, on that note, we will be taking a short Easter break next week, but we'll be back very soon and with guest contributors. So look out for that in April. But until then, you can read more on the items discussed today and many more besides by going to bulletin number 11, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now.
Have a good week.